So, contract law, super exciting. Um, okay, wait, before we get to contract, I'll just introduce myself. So I'm Julie, and most of you know I run Julie Schmidt Law. So I studied at AUT I studied law at AUT from 2018 until 2021. And while I was there, I was top of 13 law papers. And before that, I was a journalist and a lecturer in communication studies, also at AUT. And yeah, so currently I'm a full-time mum. I have a nearly 3-year-old son and a baby brain, a 7-month-old baby. So yeah, I am going to be probably returning to practice in a few years when my kids are older. And 6 months ago, I moved to Queensland, Australia, and I am loving it. All right. So, if you haven't seen my website before, here it is. Oh, that's Zoom. Here it is. Yeah, I just set up a website. I sell my notes here. I sell the notes that we'll be talking about today. Well, not talking about that I'll be using to help answer the problem question. And I have this free guide on how to make notes in my style, which I 100% recommend downloading. I was gonna make it cost money, and then I was like, I just really would love for all students to have this knowledge. Yeah. So I just had to make it free, and it's had a lot of downloads. I think it's very good. It took me months to make, so highly recommend that. I've also got this other guide on how to structure legal problem questions. So that is very useful if you're like in an exam and you want to know what approach to take. Like, do I start with writing out the elements? How do I apply the law to the facts? So that's very good. And I have made a discount code for you all. It is contract 10 off. So that's for 10% off all of my notes on my website until midnight tonight. Yeah, so that's basically just, not just for contract, for anything, for the guide, whatever. So yeah, just as a little thing for you there. All right, so that is a bit about me and the structure of this session. I just wanted to first go over my contract law notes and just like give a gist of topics and things that we're not going to cover in the problem question. And after that, we're going to answer the problem question, which hopefully everyone has had the chance to read before. And so we'll probably spend about 30 minutes on the problem question. Then I'll save a bit of time at the end for questions. You can ask me questions about contract law or just like study exam approaches in general. All right. So any questions before I jump into some topics? No, everyone seems sweet. All right, I'll share my screen and feel free also to jump in with questions in the chat or put your hand up as we go. Okay, the first thing I want to say about contract is always go back to the word reasonable. I just feel like that is such a key part of so many different causes of action in contract. It always comes back to reasonable people making a deal. So it's like, what would a reasonable person have thought they were agreeing to? What would a reasonable person believe when they read like advertising speech? What would a reasonable person feel happened when someone said, hey, I'm not going to fulfill that contract, and they attempted to repudiate it? So just always, I feel like I guess that's law in general, but I feel like especially with contract, this reasonable person comes in. And I guess the way to apply that in your exam, in my opinion, is when reading a fact scenario, think about like your opinion and what seems rational in the situation. Obviously there's a lot of law and stuff to apply as well, but I just think that's a really good thing to fall back on when it comes to contract law. Reasonable, rational, two ordinary people, two ordinary parties, just what do they agree? Okay, so our problem question's mostly about misrep, so I'm just going to skip over that now. So we've also got implication of terms. Does anyone want to say in a nutshell what is relevant to implication of terms?
Based off some of the notes, there would be meaning of the document to meaning which the document would convey to a reasonable person having background. Okay.
Yes.
So it would be it'd be something to do with knowledge or previous knowledge.
Okay, thank you, Gary. Yes, so implication of terms. Again, we're thinking of okay, wait, I'm going to the reasonable thing. So an implication of terms is if there is a contract between people and a term is so obvious it goes without saying, and it wasn't written down in the document or mentioned in the contract, it may still be a term. So it's the courts implying that that term existed. And the reason the courts would do that is because basically the agreement doesn't make sense without that implied term. Or another way of putting that is it is so obvious that that term was involved, that term was part of the contract, that it goes without saying that it was part of the contract. Gary, you have a question?
So it would be like if a contract included like the sky is blue.
Um, yeah, why not? Yeah, sure. Yeah. And Molly, you have a question?
So I was just going over a scenario, so I'm not sure if I'm on the right track. Is one of the scenarios was the guy's paying commission to the girl, and then she presents the agreement and is like, okay, sign the agreement, is you then pay the commission. Would that be an implied term?
Yes, perfect. Yeah, exactly.
But is that so obvious? Does that meet that threshold of obviousness? That's kind of
Yeah. So in that scenario, there was money that was going to be offered for a service. Is that right?
yeah, yeah.
So when the payment was due was not confirmed?
Yeah, until the agreement was presented.
Until the
So
agreement.
she then said, okay, we signed the agreement and the payment of the commission is due on that.
Oh, upon signing the agreement. Okay, so that's interesting. I'm thinking of this case, Wells and Devani. It is about an agent who was trying to sell, I think it was real estate, but I can't quite remember, sell something on behalf of someone else. And it was clear how much commission, but it just wasn't clear when the commission was going to come through. So in that case, the ruling was that after Devani found a buyer and that transaction went through, that's like the execution of the contract. So surely that's when he should get paid. And that goes without saying. So that was an implied term. I'm just thinking in your scenario, it sounds like once the contract is executed, that might not be the most obvious time. Maybe unless I would say like wait, can you clarify? Is it once the contract was signed or once the contract terms are fulfilled?
So it was kind of like performance. So he said, I'll pay you 2% commission, you find a buyer. She found a buyer, and then she arranged for the buyer. And then she's like, now there's an agreement and you pay me the commission.
Yeah.
So
Yep.
it's just the obviousness is that I'm kind of.
Yeah, for sure. I think that case, the scenario you've got is almost exactly Wells and Devani. Yeah. And like, I think the courts here were like, it goes without saying, once you've done what you said you'd do in the contract, you should get paid, because it doesn't make sense to get paid at any other time. You don't even need to write that. It's so obviously implied. Yeah.
Okay, cool. Thank you.
All right. Good question. Thank you, Molly. All right. So I think that covers implied terms pretty well. We've got cancellation of contracts. So that is a remedy. You can cancel a contract if Section 36 of the Contract and Commercial Law Act, the other party threatens to repudiate the contract. So repudiation, it's like saying that they don't intend to fulfill their end of the deal. So basically you're like, I am threatening to not fulfill my end of the deal. So for example, if I'm like sent an email 10 minutes before the session started that was like, hey guys, just so you know, I'm not going to teach this session. And let's say everyone paid $10. If you wanted to, like in between that time, the 10 minutes, this is probably a bad example, but in between that 10 minutes, oh, my screen sharing paused. Let me just get it back. In between that 10 minutes, I have repudiated the contract. So I haven't technically broken it yet, because I break it when I don't show up to that tutorial, but I've threatened to break it. So that's repudiation. So this is important. Like, let's say you have a really big commercial building company, and the person you're building, like, let's say a swimming pool for, says, hey, look, mate, just so you know, I'm not going to pay you when you finish the swimming pool. If you're the builder, you might just want to cancel the contract then and there and get out of it. So you can say, hey, look, they threatened to not pay me. They're threatening to not fulfill the contract. I'm going to get out of it. I'm going to cancel it. The coupon, I just had a question. It's contract 10 off. All right. So, yeah, okay. All right, moving on to what have we got next? Yeah, so that's a remedy. If someone repudiates the contract, you can cancel it. Or if an essential term has been breached. So an essential term of the contract. And that's where you've got a learned classification of terms, like what is essential to the contract and what is not. So it's like, yeah, you've got to look at the contract as a whole and be like, was this really part of what created this contract? Is this like part of the essence of the contract, or is it a minor term? So if it's part of the essence of the contract, you can cancel. You can cancel if there's a misrepresentation, which has had a substantial consequence on the contract performance. So, yeah. Cool. I won't keep going into that CCLA too much because that'll waste my time. Yeah. So there's a whole bunch of other things, like you can't cancel if the contract's been affirmed. Like, oh, don't worry, let's go ahead with the contract anyway, even though you repudiated it. Yeah, okay. So I'll move on because we're running out of time a bit. Okay, so we're actually not covering exemption clauses in the scenario. I said that we were in the email, but I got confused. We're actually just doing entire agreement clauses and misrep. So I'll quickly cover exemption clauses. So I like exemption clauses. It's kind of like more simple. It's just like a term in the contract which says which says like, hey, I'm exempting myself from liability from either like a whole bunch of things or a specific thing. So there are little things to think about with exemption clauses. So it has to be written clearly. You probably remember this Livingstone case where it was like a car garage and on the wall it said all care, no responsibility. So there were so many reasons why this wasn't an exemption clause, which I mentioned in different parts of my notes, but one reason was it just wasn't clear like what that means. Like all care, no responsibility. So it's like, cool, you're going to take some care. So you're not going to be negligent because you're saying you're taking care. Anyway, the courts were just like, hey, look, if you're going to exempt yourself from like liability from negligence, you got to be clear about it. Rachel, you have a question?
Yeah, just quickly. So in the problem question, there were in the marketing material, there was the clause limiting the liability of the vendor and the agent.
Yeah.
I put in there that in my sort of mock answer, what did I say? The clause was limited to the details and information contained in the brochure and advised any potential purchaser to have any details that intended to be relied upon to be independently verified.
Yeah.
We bring that in because it wouldn't have formed part of the sale and purchase agreement. It was just in the marketing material.
Yeah. You got confused about the same thing that I've been working through for like 4 hours today. So we'll get to that, but my understanding and what I've come to after really going through that is exemption clauses are in the contract itself. Entire agreement clauses are related to statements made before entering a contract. So in the marketing material, that's not the sale and purchase agreement for that real estate. That statement was made before the contract was entered into. So we're not talking about an exemption clause within a contract. We're talking about we're talking about statements made before entering the contract, whether they form part of the contract or not. And if they do, can we hold that person accountable for that statement? Does that answer your question?
Sort of.
Okay. Maybe 420. Yeah, it might be a good segue into going into the problem question because we're going through a bit of time. I'll just quickly sum up damages. Just remember, always, we're not in criminal law here. We're not punishing anyone. We're just trying to get the person back into the position that they would have been in, but for the breach of the contract. So just always think compensation, 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 not punishment. So the damages have to be the loss needs to be foreseeable. So Steel Co, they got liquidated damages, meaning like money for contracts that were breached that they couldn't fulfill because this person breached their contract. Because it was foreseeable that if they don't give us these pipes in time, we're going to breach our other contract with our suppliers.
Can I just ask a question?
Yeah, sure, Will.
on the damages. So it's not for punishing, but there are pecuniary losses, if I remember.
Yeah. Yes. Yeah, so every once in a while the courts will, yeah, thanks for bringing that up. The courts will basically try to punish someone for breaching a contract, but it's like very rare. And the other party has to have been like, I don't know how to put it other than just like bad, like kind of more on the intentionally bad side. And like the courts will want to make a point out of it so no one else does that in the future. So it's very, very rare, but it can happen. And also on damages, sometimes, yeah, if the contract was breached, but actually there were no monetary losses or any loss that you can actually prove, the courts will award nominal damages or damages in name. So if you read a judgment with nominal where they provide this remedy, it's like, all right, yeah, we see that you breached the contract. That sucks. Look, you haven't actually lost anything. We'll award you $2. So very occasionally people can be better off than they were because of the breach. That's called betterment. And that yeah, that means you'll probably get nominal damages, if any, because you're doing fine. You're not needing to be compensated. So also in contract law, damages, you can get damages for stress. Like, I like this one. Someone went on a holiday and it was like very stressful, and because the purpose of the contract was to relax, and that contract was therefore breached, therefore he got damages for stress. But generally in like any commercial type of contract, it's expected to be stressful. For example, if you're building a driveway in Wellington and you're dealing with contractors, it's just a given it's going to be stressful. This is commercial reality, so you're not getting any damages for your stress. Okay, so Gary, you have a question?
So with the nominal damages, it's like, well, you haven't really had anything damaged per se, but here's compensation anyway.
It's not compensation. It's the court saying, we're going to recognize that a wrong was done to you. Someone breached the contract with you, but since you haven't lost, and the main principle for damages in contract law is compensation, what can we give you? So they just say, like, here's $1, just to recognize that legal wrong in court, but there's nothing that you can actually get.
Okay, another quick one. What was the one with the holiday in the street? What's the name of the case?
This one is Jarvis. Yeah, I like this case because it's just like a guy getting really pissed off about his holiday being ruined. It's funny. Okay. All right, so I'm going to move on from this and I'm going to move to the problem question. So I'm really glad that Rachel has already brought up the differences between, brought up this issue that was just, I've been working through this for a while, but anyway, we'll get to that. So I think everyone has probably had the chance to read it. If not, just very quickly, we're dealing with a woman who wants to buy a house with no issues to it. She doesn't want to spend anything. She doesn't want to renovate it. Having bought a house that you need to renovate, I can completely feel where she's coming from. It's such a hassle, takes so much time and money. Anyway, so that was one of her main things that she wanted in a house. And she went to this house, which was described in some pamphlet, that there was nothing to spend. It's got perfect presentation. Inside that pamphlet, there was this disclaimer which saying there's no liability to the vendor. for any error or omission, and it's not intended to be part of the contract. And hey, it's all on you. You should independently verify everything about this house. At the open home, she also asks the agent about the house, and she said it's been recently refurbished. The exterior was painted a year ago, and it's generally well maintained. And yeah, so she bought the house, and then upon moving in, she realizes there are cracks. So good old leaky buildings in New Zealand, and it costs 50K to repair. So she is trying to sue because there's obviously something to spend, and she didn't want to do that. All right. Okay. How do I go about? We'll start with misrepresentation, because I would say, like, what do you guys think we should sue on? But I think everyone here would know she would like to give misrepresentation a go.
I'd say the same thing.
Yeah. Sweet.
Hang on, I would like to point out that the agent or the VIN.
Okay, I'm just gonna mute you, Gary, and just keep going. Sorry. All right, so let's go through the elements of misrep quickly. Okay, so misrep, it's like there was something said before the contract was entered into, and it did not accurately represent some part of the contract. So you want to get out of the contract or have some compensation, because you're like, hey, you told me this, that wasn't true, and I entered into that contract because of that thing you told me before we signed our deal or made the official deal. So the question is, whether the contract can be avoided, or whether you can get damages because of a statement made leading up to the creation of the contract. And we are in section 35, mainly of the Contract and Commercial Law Act. So, yeah, that's where we are. This section is important. Go through it again and again. It's kind of wordy, and the A and the B, yeah, it took me a long time to read. But anyway, we're in section 35, the Contract and Commercial Law Act. So the elements are, there was a misrepresentation. It was made by or on behalf of someone party to the contract. To the point. The statement must be false. It induced the plaintiff to enter the contract, or was a material inducement. So it doesn't have to be the only reason they entered the contract, but it's got to be a pretty big reason. Loss was suffered, and then the remedies you can get are damages 35 or cancellation 37. So remembering with cancellation in 37, you've got to, if there was a misrepresentation, it has to have been substantial. So don't forget to read 37(2)(b). In order to cancel a contract for misrepresentation, the breach has to have been substantial.
What about 2A, where it needs to be essential?
The parties have expressly or impliedly agreed that the truth of their representation.
I would have thought that the property not needing to have anything spent on it was pretty essential to Valerie.
Okay, I hear you. We're jumping ahead. I'm just going over the elements quickly, and then now let's answer the question. So first of all, who wants to say, in relation to our problem question, were there any misrepresentations made? Element 1. Were there any misrepresentations made? Got a thumbs up. I'll check the chat. Yes, Tanya says yes. Will's nodding his head. Yep. Yep, Rachel's nodding her head. Okay, Cool. I think everyone can see nothing to spend. Perfect presentation. Recently refurbished, repainted a year ago. Oh, that's actually true. Generally well maintained. Okay, so there was a statement of fact about the current state of the premises. So remembering with misrepresentation, it can't be a fact about the future. It has to be a past or present fact. Because no one is a oracle and can give facts about the future. That's what the courts think and say. So honest opinions are normally okay because you're not lying. You genuinely think it's true. If you're silent, it's generally fine. It's on the buyer or the other party of the contract to do some due diligence. But if you say half the truth, then that's a misrep, because it was you put something out there that was only half the truth. Therefore, you represented that half truth was the whole truth. So that counts. And relevant to our question is mere puff. So who knows what mere puff means? Yep, we've got a hand up. Does someone want to jump in and say how you would apply the subcategory of mere puff to element 1?
What do you mean?
I mean, if you're in an exam and you're answering this question, we're writing element 1. How would you bring up mere puff, if you would at all?
Carbolic smoke ball.
Okay, that's case related to mere puff. Yep. It's when someone says something that doesn't have a good definition. Yes, that's good. Yep. Yes, imprecise. Yep. It's like, whoa, this is amazing.
Jargon.
Sorry, go ahead.
Marketing jargon.
Marketing jargon. Great. Yes.
Could you say statements made with the deliberate intent of exaggeration?
Yeah.
And would it matter if would it matter if the puffery includes a fact?
Okay.
Mere puff is just
Think
a
about that.
statement that's just it's outrageous that no reasonable person would believe.
Yes. I'm just going to think about answering Will's question. Does it matter if it is a statement of fact? That's a good question. So the reason that something would be considered mere puff is because it's terms that are mere puff are incapable of precise definition. So if you say, this tutorial was excellent, it's like, maybe that could be defined actually. In closure pack, excellent was capable of being defined. But let's say it's like, this was the most amazing tutorial. It's like, is that actually a statement of fact? Because what does that mean? And an amazing tutorial might mean different things to different people. So if the statement can be proven, if the statement can be a definable objective fact, then that wouldn't be mere puff. If it is incapable of being defined, then it would be mere puff. Yeah, so I'm thinking of closure pack. The words, they were like modern, efficient. Yeah, here we go. Excellence, magnificent, splendid generally don't convey a specific meaning, but excellent could be relied upon because that's more capable of definition. Okay, I'm gonna go back and check the chat because there are a few other points which I haven't gotten to. So we have, when the brochure says perfect presentation, that doesn't really mean anything. Yeah. It's open to interpretation and is a statement unlikely to be taken seriously. Yes. All right. So yes, I think perfect presentation, like for sure. Does that mean that it's got lovely couches and like lovely dining table? Does that mean it is like a house that doesn't need renovation on cracks? Like, it's really not clear. So that would probably be a statement that's mere puff, incapable of definition, and therefore not something a reasonable person should rely on. Remember, we're always coming back to that reasonable person. Yeah, pleasing to the eye, exactly. Is it just like old and crappy, but like beautiful, you know, like some hippie shack? Is that perfect presentation? So the reason mere puff comes into play is, yeah, if a word or if a definition is so imprecise and unclear and so obviously just marketing that a reasonable person shouldn't rely on it as being part of a definition, as being something that's defining a future contract, then that will not count. Because if a reasonable person wouldn't rely on it, you can't then say that you agreed to this contract based on that statement when a reasonable person wouldn't rely on that. Tanya says, in terms of definable terms / facts, the statement, generally well maintained, that's hard to define, but seems like something that is capable of being verified. So which way does it go? Or is it opinion? Yeah, good one. Yes. Any thoughts from the audience?
Yes, I've got a thought on that. So if it's an opinion, the traditional rule is that it's not a misrepresentation. Am I right? But if that opinion implies a fact, then it can be held to be a misrep.
Yes. Yep.
Is that what she asked?
Is that what you asked, Tanya? That's hard to find. Yeah, I think that's. No, I can't speak for Tanya, actually. I don't know. Is that what you asked? Yeah. Yeah. So I guess I think you're saying, is the term generally well maintained, is that mere puff? Is it an opinion or is it a statement of fact? I would tend to say that that is a statement of fact, not mere puff. It's not like it is absolutely amazingly maintained. I think well maintained is somewhat precise. It's not exact, but you know, it means like there probably won't be many issues with it. It's generally pretty good. And I don't know if she could argue opinion here, because it's not, you know, this is an agent who has a lot of knowledge about the house, and then she's saying, yeah, it's well maintained. I think an opinion, I think it's coming across as a statement of fact. If it were an opinion, it would be like, oh, geez, did you watch the cricket? I think that New Zealand's team is terrible. Like, that's obviously an opinion.
Wouldn't it be? Couldn't you sort of say that that specific statement, right? About the generally well maintained house, I believe is the question, right? So wouldn't you say if both parties have knowledge, that would indicate opinion, but if only the agent had knowledge, then it would be fact?
Let me think about that.
Is her generally well maintained being backed up with it was painted and they lived in the house for 5 years? So that's where it's kind of aligning to the fact.
Mm-hmm. Yeah, good point. Like looking at them all in context, does that indicate knowledge?
Yeah, because in context, she goes to the open home, so she can see paint and the stuff. The issue with the soil erosion, that's different to generally well maintained.
Yeah. Yeah, I think that's a good point. I think the only thing I'd argue with is the parties clearly don't have the same amount of knowledge about this topic. But you're saying if they did, I don't know if I don't know if in the situation of a buyer and a seller, if there's ever an equal amount of knowledge about a topic. Surely the person selling always has more information. Could be wrong there. But in this case, it's definitely she is the agent. She should be the expert on the house. And Valerie is a buyer and she should not be an expert on the house. But your question, if two people have the same amount of knowledge, is it opinion or is it fact? I think it would, depend on the way it's said, because some people say, I give the classic answer. It would depend on the context, I think. I don't know if there's a general rule for that. All right, so I'm just going to check my notes to make sure we've covered everything about misrep element 1 here. Yep, so what about silence? Silence. Did she... Oh, I got some... I think I'd say that it's a fact, but even if it were opinion, it's offering the statement of fact, which is generally capable of being a misrep. Oof, good answer, Tanya. Yep. Tanya's got a good answer in the chat. Okay. Oh, I just looked at the time. Cool. I'll just go a little bit faster because we're running out of time here. Yep. So generally silence, not a misrep, but if you, again, the half-truth thing. So maybe this was a half-truth. Like she said, it's well maintained, but she didn't expose the cracks. The owners had also been living in the house for 5 years. So they would probably, you'd think they'd know about the cracks. Also, did they paint the house to cover up the cracks? And also when they painted the house, wouldn't they have known about the cracks? So there's some sort of issue here, I think, with the painting. Yeah. Yeah, so we have also, let me go quickly since we still have to cover entire agreement clauses. Yes, the state element 2, yes, it was made by the agent. That counts as being made on behalf of the party. Was the statement false? Yes, they were. That wasn't well maintained. Did it induce? Okay, we'll quickly go forward. Did it induce her to enter into the contract? Yep. That's what that was one of the main things she wanted. Doesn't have to be the only thing she liked about the house, but it's fair to say that that was a material or major thing that induced her to enter the contract. Yeah, so I would say, what do you guys think? Would she be able to successfully sue for misrep, and what would she get if she did?
Yep, she would be successful in misrep, and she could probably go for either the section 35 damages or section 37 cancellation, depending on what she wants to do.
Yep. Okay, so you would say it's a substantial misrepresentation enough to get the cancellation. Yep. Yep, someone else want to jump in? Yep, I agree. What about like for everyone who's bought a house, you know that you're expected to get your own building reports, limb reports. What about the reasonableness of her relying on something random that, well, not necessarily something random, relying on something that the agent has said at an open home and not doing her own due diligence? Does this relate to the reasonableness of her reliance and whether it was reasonable that she was induced to enter the contract based on those statements in that brochure?
Potentially. Well, I mean, if she is the real estate agent, then she has knowledge of the house. She's gone through the house, etc., etc.
Yep. Yes, and in the chat, Tanya said she's a first home buyer, so she might not know these things. That's a really good point. We don't know who she is. If she is a property developer and she's bought and flipped 30, we would expect someone in that position to do their own due diligence and not rely on a agent. But maybe if she's a really naive person, it was reasonable for her to rely on that and not get her own reports done. We've got Matt saying if she sought damages, could she also cancel the contract? Or is it a one or the other type thing? If you cancel the contract and you have lost as a result of needing to cancel that contract, you could get damages as well. So let's say you're going through your let's say she put a 10, no, it's New Zealand. Let's say she put a 200K deposit down to buy this house and she wanted to not go through with this sale. She could cancel the contract so she doesn't have to go through the sale and then try and claim damages for that 200K. So the answer is yes, you could do both. All right. So that's just another thing to think about, whether her being induced to enter this contract was a reasonable inducement. All right, let's move on to entire agreement clauses. So again, I am right with you guys if you're confused, because I have been confused about the difference as well up until I just spent so long on it today, and then I really got my head around it. So like I said earlier, my understanding is exclusion clauses are in the contract. They form part of the contract. That's why in that case, Ollie and Marlborough Court, this is the one where they get a hotel, some of their stuff gets stolen, and they try and sue the hotel. And the hotel says, whoa, 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 when you get to the door of the hotel, it says that we're not liable for anything that you have, for anything that gets stolen. And this case said that exclusion clause doesn't apply because the contract was made at the reception desk. You said, I'm going to get this room for this amount of money. The contract was executed at that desk. So when you later went up and walked to the hotel door, the contract was already made. That's not a term of your contract. So exclusion clauses need to be part of the contract. That means they need to be brought to the attention of the party before the contract is executed. And if the clause is particularly onerous, it needs to be potentially really pointed out to that person. Anyway, I'm getting on a tangent. Okay, so that's exclusion clauses, part of the contract. Entire agreement clauses are, if I go to section 50 of the Contract and Commercial Law Act, Entire agreement clauses are, oh, the Zoom is blocking my, there we go. Okay. They're statements, promises, or undertakings made during negotiation. So if a contract or any other document says that a court can't look into whether a statement made before creating a contract is allowed, then Section 50 will say the courts might jump in and say, no, we can look into that statement. So to say that again, hopefully in a more simple way, it's if there is a statement or something made while during the negotiation phase, and there is a clause in that contract or in a document before the contract saying, hey, look, this contract is the entire agreement. No misrepresentation or any representation made before we execute this contract counts. If that clause exists in the contract or in a statement or document before the contract exists, then that's the entire agreement clause, and they don't always have to be upheld. The courts might say, no, we're not going to uphold this entire agreement clause, especially if there are two commercial parties who are making a bargain. And yeah, so the courts say it depends on the value, the subject matter and the value. So the cases are like, if it's commercial parties with a lot of money involved in the contract, you want more certainty. And it's more reasonable to expect that it would be contained in the four corners of the document. We're looking at the bargaining strength of the parties. So whether, let me just find this. Yeah, the bargaining strength of the parties. So is there is it a business to consumer? Is it a business to business? Do we have, is it a standard clause? Like when you accept Facebook's standard terms, were you able to negotiate, or was it just fully put on you, non-negotiable standard clause? And whether any party had legal advice. So those are the factors that the courts will consider, and others. So let's go to our problem question. She will be arguing that I'll take a break. Just is said after settlement, so presumably she's paid for the house. Yep. Rachel said it is said after settlement, so presumably she's paid for the house.
By that I meant she won't get cancellation. It'll be damages, because it'd be a bit hard to cancel an agreement after you've paid. You just get reimbursed for any costs you've incurred.
Okay. Yep.
Eventually the $50,000 to repair the damage.
Yeah. I would say, yeah, the contract's already been executed. That's a tricky question. Can she get cancellation even though the contract is already executed? I would say she could, because she might want to undo, instead of going through the effort of selling the house. Wait, I better not talk because I'm not 100% clear on this. Does anyone else know? I'm actually not 100% clear on that.
Well, once settlements happen, it means money's changed hands and she's moved in.
Yes, but she wants to potentially cancel a contract that's already been executed. So that means that that person, the seller, will get their house back. They don't have, it wouldn't be a buyback. It would be as if the contract was never in existence, so annulled. That would, I
I
would
don't think that ever happens.
Yeah. No, I've worked in property as well. It's not like a standard thing to happen. I
No.
guess it's asking the legal question of if a contract has already been executed, can you cancel it as if it never existed?
Before settlement, certainly.
I don't want to, I don't know. I don't want to say you're right or I'm right. So let's just leave it there because I'm not 100% sure on that. Because repudiation is cancelling a contract that hasn't yet been executed, that's been threatened to not be executed. So my hazy memory and God is telling me that if a contract's already been executed and you want to annul it and say that and cancel that contract, because an essential term was breached, I would say I'm thinking you could, but I'll get you guys to do your own due diligence on that answer. And we've got, what about the small print? Yeah. Yep. So that would relate to whether it's so onerous that it might need to be pointed out. Maybe it needed to be drawn to her attention because it was a particularly onerous clause. But it doesn't appear to be too small. So yeah, but that would definitely be worth bringing up for sure. All right, so we're nearly out of time. Yeah, yes, exactly. Technically possible, but highly. I think the main question with that cancellation is, can you cancel? Oh, I don't want to talk about it anymore. You know what it is. Can you cancel a contract that's already been executed? All right, I'm just going to check my answers that I've prepared to make sure we've covered everything. Okay. And yeah, so basically, will the courts, the entire agreement clause was in, it wasn't a document contained outside of the contract, but that still counts. And it was saying that nothing said here is intended to be part of any contract. And will the courts give her relief under Section 50 and say that this doesn't apply? And I'll just say it because we've run out of time. It's potential. There's potential because, you know, she's not a big business making a business to business transaction. She's a consumer. We don't know how naive she is or how experienced she is, so we can't comment on that. But this case, Snodgrass and Hamilton, it's similar facts. So there was residential property purchased in reliance on representations made by the party and the agent that there was no subsidence problems. They later found the problems, and the clause said, purchase at your own judgment, no representation made by a real estate agent counts, blah, blah, blah. And the purchaser won. So it was the real estate agent's standard clause. There was no legal representative. There was not equal bargaining power. The exclusion clause was in small print. Nice one, Will. And they were careless in making those statements. So in this case, the court stepped in and said, we're going to apply Section 50, and we're going to say that the exclusion clause doesn't apply, and that we can look at statements made before the contract was entered into, and we could sue for misrepresentation. And you can sue for misrepresentation in reliance on a statement that was made before the contract was entered into. And yeah. Okay, so we're at 5 o'clock. I will share a document in the chat again for all of those who missed it. Oh, or actually, maybe I won't yet because it's not popping up how to do that this time. Okay, thank you so much for coming to my tutorial. That went really fast for me. I hope that you all had as much fun as I did. Probably not, because it's always the funnest to be the person talking the most. But anyway, yeah, thank you. It was lovely to have this session with you all. Before jumping off, if you did like the session, if you wouldn't mind leaving a comment or like a testimonial in the chat, and I can use this potentially for future marketing of my webinars or tutorials, that would be great. Yeah, if you'd like to buy the notes, it's contract 10 off. And yeah, I personally think my notes are amazing and that they will definitely help you a lot. They structure the law well, and yeah, they've got a lot of bonus cases in there. A lot of thought has gone into every color and every different thing that I use. So, all right. Thanks everyone. Yeah. Thanks, Will. Thanks, Jasmine. Yeah, this is my final one for this year. I've had so much fun, and I will likely be doing some next semester. So that's 2024. Whoa, that's a long time away. Yeah. So yeah, keep in touch. My email is julie@julieschmidtlaw.com. And
Are you still using Substack?
No, I'm not anymore. No. Yeah, thank you for you're even on my Substack. I hardly had anyone on that. Yeah, thank you. So I've got a newsletter that comes out every Monday, and I've put a lot of thought into what to put in my newsletter. So it's often about study motivation or my personal tips. So if you want to subscribe to my newsletter, there is info on how to do that in my document, but it's not coming up. Hold on, let me just try and find a way to get the document in.
Your tip of just do 10 minutes has helped me so much this week.
Oh, I'm so happy to hear that. That's amazing. Yeah, honestly, it's so, yeah, same for when I was studying. I just had so much like, I have to do 10 hours and then I'll do nothing. Okay, it's not coming up. I know what I'm going to do to get around this. Here we go. Yeah, so this is the link. There it is, to sign up to my weekly newsletter. And thank you, Rachel, for that feedback. Really appreciate it. And I love doing the newsletter. I think, yeah, it's really fun. But I'm not using Substack anymore. I've switched to MailChimp, so it just comes through as a normal email. And yeah, if you haven't already got my free guide on how to make exam notes, highly recommend getting that. I do have a guide on how to structure answers to legal problem questions. So it's using a torts example, but it will apply to contract. It applies to anything. And yeah, I have a model answer from a torts question, but yeah, that will apply to all of them. It'll give you a good game plan for going into an exam and knowing how to structure your answer. And yeah, I really need to figure out how to download this. I've got links to links to all my documents, all the notes. Oh, did that work? Jeepers. Not really. Okay. Why don't I just do this? Here we go. Sorry, I don't know why this technology is doing this today. If you want the links, here they are. Because you can't really copy and paste like, HTTP.
Awesome. Thanks, Julie.
No worries.
Thanks.
All right. Thank you, everyone. I will just take some screenshots of the chat so that I don't lose people's testimonials. But yeah, thank you all for coming. So nice to talk to you all. And yeah, hope to keep in touch. Good luck with your
This
exam.
has been fun.
Yeah, thanks for your participation, Gary. I really appreciate it.